I was standing in my driveway at 7 in the morning when Patricia Henderson marched across the street with her phone pointed at my backhoe, like she was documenting a crime scene. The yellow Caterpillar 420F sat exactly where I had parked it the night before, mud still caked on the tires from the work I had been doing in my backyard. I had owned the property in Boulder Creek, Colorado for 3 years now, and this was the first time anyone from the HOA had bothered to complain about my equipment. The subdivision sat on the edge of town where residential met rural, and half my neighbors had trucks bigger than my backhoe anyway. "Excuse me, Brandon," Patricia called out, her voice sharp enough to cut glass. "I need to speak with you about this monstrosity you have parked in plain view." I turned around, coffee mug in hand, and gave her my best neutral expression. Patricia was the HOA president, a position she treated like she was running a small nation rather than a neighborhood with 40 houses. She wore her usual outfit of expensive activewear that had never seen actual activity and oversized sunglasses, despite the early morning hour. "Morning, Patricia. What seems to be the problem?" She lowered her phone but kept it ready, like she might need to call the authorities at any moment. "This construction equipment is a direct violation of our HOA covenants, conditions, and restrictions. Section 12, Paragraph 4 clearly states that commercial vehicles and equipment cannot be stored on residential properties in view of the street." I took a sip of my coffee. "That backhoe isn't commercial. I own it personally, and I am using it for work on my own property." "That is irrelevant," she snapped. "The covenant does not distinguish between commercial and personal ownership. Large equipment of this nature is prohibited. You have 24 hours to remove it, or the HOA will be forced to take action. Take action." I set my mug down on the hood of my truck. "What kind of action?" Patricia's lips pressed into a thin line. "We have the authority to impose fines, place liens on your property, and if necessary, arrange for the removal of prohibited items at the owner's expense." "I suggest you take this seriously, Brandon. I have already documented this violation with photographs, and a formal complaint has been filed with the HOA board." She turned on her heel and marched back across the street to her house, leaving me standing there trying to figure out what had just happened. I had lived in this neighborhood peacefully for 3 years. I kept my lawn maintained, I did not throw wild parties, and I generally minded my own business. But 6 months ago, I had started a personal project that had apparently put me on Patricia's radar. The previous owner of my property had been an old prospector named Dale Carson, who had lived here since the 1970s. When I bought the place, it came with a lot of old mining equipment in the shed and some interesting paperwork that I had not paid much attention to at first. But last winter, while organizing my garage, I found a metal box containing mineral rights deeds and old surveys that showed my 5-acre property sat on top of a small but legitimate silver vein. Colorado has a long history of mining, and property rights here can be complicated. Surface rights and mineral rights can be owned separately, but in my case, I owned both. The deeds dated back to 1873, and through a chain of title that I had verified with a lawyer, those mineral rights were completely legitimate and had been properly transferred through every sale of the property. I was not planning to open a commercial mine or anything crazy like that, but I was curious, and I had the equipment and the skills to do some exploratory digging. I had worked in construction for 15 years, and I knew my way around heavy machinery. So I bought the backhoe, got the necessary permits from the county, and started carefully excavating in my backyard where the old surveys indicated the vein ran closest to the surface. The work was slow and methodical. I was not tearing up my whole property, just digging in a specific area that I had marked off and properly secured. The county inspector had come out twice and found everything in order. I had all my permits posted, my excavation was properly shored up, and I was following all the safety regulations. But apparently, Patricia Henderson did not care about any of that. I finished my coffee and headed inside to get ready for work. I had a construction job in Denver that would keep me busy for the next few days, so I did not have time to deal with HOA drama. I figured Patricia would cool off once she realized I was not breaking any actual laws. I was wrong. 3 days later, I came home to find a certified letter taped to my front door. Inside was a formal violation notice from the Ridgeview Estates Homeowners Association, signed by Patricia Henderson as president and 2 other board members I barely knew. The letter stated that I was in violation of Section 12, Paragraph 4 of the HOA covenants, and that I had 7 days to remove the backhoe from my property or face a fine of $250 per day until compliance was achieved. The letter also mentioned that if the fines remained unpaid for more than 30 days, the HOA could place a lien on my property and potentially foreclose to recover the debt. I read the letter 3 times, feeling my blood pressure rise with each pass. This was insane. They were threatening to take my house over a backhoe parked in my driveway. I grabbed my phone and called the only lawyer I knew personally, Marcus Webb, who had helped me with the property purchase and the mineral rights verification. "Marcus, I need your advice on something," I said when he picked up. "Hey Brandon, what's going on?" I explained the situation, reading him the exact wording of the violation notice. Marcus listened quietly, and I could hear him typing in the background. "Okay, first thing, don't panic," he said. HOA covenants are enforceable contracts, but they are not unlimited in what they can do. Send me a copy of your HOA documents, especially the CCRs they are citing. Also send me the violation notice. I will take a look and get back to you tomorrow. I scanned everything and emailed it to him, then spent the evening researching HOA law in Colorado. What I found was not encouraging. HOAs in Colorado had broad powers to enforce their covenants, and courts generally upheld their authority as long as they followed their own procedures and acted reasonably. But the key word was reasonably, and I was not sure threatening to foreclose over a backhoe counted as reasonable. Marcus called me back the next morning while I was driving to my job site. "I have reviewed your documents," he said, "and I have good news and bad news. The bad news is that the covenant they are citing is pretty broadly worded. It prohibits commercial vehicles and large equipment visible from the street, and a backhoe probably falls under that definition." My hands tightened on the steering wheel. "And the good news? The good news is that we might have a few angles to fight this. First, the covenant says commercial vehicles and equipment, and you can argue that your backhoe is for personal use related to your property. Second, and more importantly, if you are using the backhoe in connection with your mineral rights, there might be a state law preemption issue." "What do you mean?" "Colorado has strong protections for mineral rights," Marcus explained. "Mining law is governed at the state level, and in some cases, state mining regulations can supersede local ordinances and private covenants. If you can show that your backhoe is necessary equipment for exercising your legal mineral rights, the HOA's covenant might not be enforceable against you." I felt a surge of hope. "I have all the mineral rights deeds and my county permits. I am actively doing exploratory excavation." "Perfect. Here is what I recommend. Write a response to the HOA explaining that you are exercising your legal mineral rights, which are protected under Colorado law. Cite the relevant statutes, I will send those to you. Tell them that their covenant cannot interfere with your state-protected rights. Be polite but firm. That might be enough to make them back off. And if it's not, then we might end up in court, but I think we have a strong case. The intersection of mineral rights and HOA covenants is not something that comes up often, but when it does, mineral rights usually win. Those rights predate most HOAs by decades or even centuries, and the law tends to protect them. I thanked Marcus and asked him to send me a draft response I could use. By the end of the day, I had a formal letter ready to send to the HOA, explaining my position and citing Colorado revised statutes relating to mineral rights and mining operations. I hand-delivered the letter to Patricia Henderson's house that evening. She answered the door in another set of expensive activewear, looking annoyed at the interruption. "I got your violation notice," I said, handing her the envelope with my response. "This explains why I believe the covenant does not apply in my situation." She took the envelope but did not open it. "The board's decision is final, Brandon. If you do not comply, we will proceed with fines and enforcement. I would encourage you to read the letter and consult with the HOA's lawyer before you do that," I said, keeping my voice level. "I am exercising legal mineral rights that are protected under state law. Your covenant cannot override that." Patricia's eyes narrowed. "This is a residential neighborhood, not a mining operation. You cannot just dig up your property and claim mineral rights give you the authority to ignore our rules." "Actually, I can, if those mineral rights are legitimate and properly documented, which mine are. I have county permits, I am following all safety regulations, and I am operating within my legal rights. I suggest the board take this seriously before you waste everyone's time and money on a legal battle you will lose." I walked back to my house before she could respond. I knew I had probably made things worse by being direct, but I was tired of being pushed around over something that was completely legal. The 7-day deadline came and went. I did not move the backhoe. 2 days later, I received another certified letter informing me that I was now being fined $250 per day for non-compliance, starting immediately. The letter also stated that the board had reviewed my response and rejected my argument regarding mineral rights. I called Marcus again. "They are not backing down," I told him. "They started the daily fines. Okay, time to escalate. I am going to file a lawsuit on your behalf, seeking a declaratory judgment that your mineral rights take precedence over the HOA covenant, and an injunction preventing them from enforcing the fines. This is going to cost you some money in legal fees, but I think we can win." "Do it," I said. "I am not letting them bully me into giving up my rights." Marcus filed the lawsuit in Boulder County District Court the following week. The complaint laid out my ownership of the mineral rights, my compliance with all county and state regulations, and the argument that Colorado mining law preempted the HOA's covenant. We asked the court to declare that the HOA could not enforce the covenant against me, and to enjoin them from imposing fines or taking any other action related to my backhoe or mining activities. The HOA filed a response 3 weeks later. They hired a law firm out of Denver that specialized in HOA representation, and their response was aggressive. They argued that HOA covenants were enforceable contracts that I had agreed to when I purchased the property, that my mining activities were a nuisance to the neighborhood, and that mineral rights did not give me unlimited authority to violate community standards. The legal battle dragged on for months. Discovery was contentious. The HOA demanded documents about my mining activities, my income from any minerals extracted, and my plans for future excavation. I had to sit for a deposition, where their lawyer grilled me for 4 hours about everything from my construction background to the exact location of the silver vein on my property. Meanwhile, Patricia Henderson ramped up her campaign against me. She sent letters to all the homeowners in the subdivision warning them about my activities and claiming I was turning the neighborhood into an industrial zone. She posted on the neighborhood Facebook group with photos of my backhoe and dire warnings about property values declining. A few of my neighbors started giving me cold looks when I drove past, but not everyone was against me. My next-door neighbor, an older guy named Tom Bradshaw who had been friends with the previous owner Dale Carson, stopped by one evening while I was working in my garage. "Hey Brandon, I just wanted to say I think what Patricia is doing is garbage," Tom said. "Dale had those mineral rights for 40 years and nobody cared. Patricia just does not like that you are not kissing her ring." "I appreciate that, Tom. This whole thing is ridiculous." "Dale used to talk about the silver vein," Tom continued. "He did some digging back in the 80s, but he was too old to do much with it by the time I moved in. He always said it was good silver, though. Have you found anything?" "A little," I admitted. "Nothing huge, but there is definitely silver there. I am not trying to get rich off it. I just want to see what's there and maybe pull out enough to cover my equipment costs." Tom nodded. "Well, if you need someone to testify that this property has always had mining potential and that Dale maintained his mineral rights, I will do it. Patricia needs to learn that she does not run the whole world." I thanked him, and Marcus added Tom to our witness list. As the case moved forward, we reached a point where the judge scheduled a preliminary hearing to address the injunction request. This was not the final trial, but it was important because if we could get the judge to stop the HOA from imposing fines while the case was pending, it would relieve some of the financial pressure. The fines had been accumulating for months, and the HOA was now claiming I owed them over $20,000. The hearing was set for a Tuesday morning in late September. I took the day off work and met Marcus at the Boulder County Courthouse. It was a modern building with lots of glass and natural light, which somehow made the whole legal proceeding feel less intimidating than I had expected. We sat at one table, and the HOA's lawyers sat at the other. Patricia Henderson was there too, dressed in a business suit and looking confident. The judge was a woman in her 60s named Judge Sarah Mendoza, who had a reputation for being fair but no nonsense. The HOA's lawyer went first, arguing that this was a straightforward case of covenant enforcement, and that my mineral rights claim was a distraction from the basic fact that I had agreed to follow the rules when I bought my house. "Your Honor, the defendant purchased his property with full knowledge of the HOA covenants," the lawyer said. "These covenants exist to maintain property values and community standards. The defendant cannot simply ignore them because he finds them inconvenient." Then it was Marcus's turn. He stood up and addressed the judge with a calm confidence that made me feel better about our chances. "Your Honor, this case is not about convenience. It is about the hierarchy of property rights under Colorado law. The mineral rights that my client owns are not some minor detail. They are real property rights that date back to 1873, long before this subdivision or its HOA even existed. Colorado has a strong public policy in favor of mineral development, and courts have consistently held that mineral rights holders must be allowed reasonable use of the surface to access their minerals." Judge Mendoza looked at the documents in front of her. "Mr. Webb, do you have proof of these mineral rights?" "Yes, Your Honor. We have submitted the complete chain of title showing my client's ownership of both surface and mineral rights, along with the original deeds from the 1870s. We also have county permits for the excavation work and inspection reports showing full compliance with safety regulations. The judge turned to the HOA's lawyer. "Counselor, does your client dispute the validity of the mineral rights?" The HOA lawyer hesitated. "We do not dispute that certain historical mineral rights may exist, Your Honor, but we contend that those rights do not give the defendant unlimited authority to violate community standards and covenants that he contractually agreed to." Judge Mendoza flipped through more papers. "What exactly is the defendant doing with this backhoe that is causing such concern?" Marcus answered. "He is conducting exploratory excavation in his backyard, Your Honor, in a specific area where old surveys indicate a silver vein. The work is limited in scope, properly permitted, and in full compliance with county regulations. The backhoe is necessary equipment for this work. When he is not actively using it, he parks it in his driveway because he lives on a 5-acre property with ample space." "And the HOA's objection is to the backhoe being visible from the street?" the judge asked. "Correct, Your Honor," the HOA lawyer said. "The covenant prohibits commercial vehicles and large equipment from being stored in view of the street. This maintains the residential character of the neighborhood." Judge Mendoza sat back in her chair, looking thoughtful. "Here is my concern with the HOA's position. If the defendant has legitimate mineral rights and is conducting a legal mining operation, even a small-scale personal one, then the backhoe is not just some random piece of equipment. It is a necessary tool for exercising a fundamental property right. Colorado law is very protective of mineral rights, and I am not convinced that an HOA covenant can prohibit someone from having the equipment necessary to access their own minerals." The HOA lawyer stood up quickly. "Your Honor, if we allow this, where does it end? Could a homeowner claim mineral rights and then park a fleet of mining trucks in their driveway? Could they build an industrial-scale operation in a residential neighborhood?" "That's a fair question," Judge Mendoza said. "Mr. Webb, what is your response?" Marcus was ready. "Your Honor, the reasonableness standard applies here. My client is not running an industrial operation. He is one person with one piece of equipment doing careful, permitted excavation work on his own large property. The Colorado Supreme Court has held that mineral rights holders are entitled to reasonable use of the surface, and what is reasonable depends on the specific circumstances. In this case, parking a single backhoe on a 5-acre residential property while conducting legitimate, permitted mining work is clearly reasonable." Judge Mendoza nodded slowly. "I am inclined to agree. However, I want to see more evidence before I make a final ruling. I am going to order a site inspection. I want to see this property myself and understand exactly what we are talking about here." Both lawyers agreed, and the judge scheduled a site visit for the following week. This was unusual but not unheard of, and Marcus told me afterward that it was actually a good sign. It meant the judge was taking the mineral rights issue seriously. The site visit happened on a bright October morning. Judge Mendoza arrived at my property with a court reporter and a clerk. Both legal teams were there too. I had spent the previous week making sure everything was clean and organized, with all my permits posted and my excavation site properly secured. I walked the judge around my property, showing her the old survey maps and explaining how I had located the silver vein. We went to the backyard where I had been digging, and I showed her the shoring and safety measures I had put in place. I had also prepared several small samples of silver ore that I had extracted, which I showed her in labeled containers. "This is the original survey from 1879, I explained, holding up a laminated copy. "You can see where the surveyor marked the vein running through this section of the property. I cross-referenced it with modern GPS coordinates and started my excavation here. Judge Mendoza examined the survey with genuine interest. And you have found actual silver? Yes, Your Honor. Not a huge amount, but enough to confirm the vein is real and worth exploring. I have had the samples assayed. The silver content is approximately 12 ounces per ton of ore, which is decent quality. She looked at the excavation site, which was a careful trench about 15 feet long, 8 feet wide, and 10 feet deep. It was not a huge operation by any means, more like a large test pit. The walls were properly sloped and shored with timber supports, and I had a pump system to keep it from flooding. This is impressive work, the judge said. You clearly know what you are doing. I have been in construction for 15 years, Your Honor. I am comfortable with excavation and safety requirements. We walked back to the front of the property where the backhoe was parked. Judge Mendoza stood in my driveway and looked around at the neighborhood. My property was at the end of a cul-de-sac, and the backhoe was visible from the street but not particularly obtrusive. It was just sitting there like any other vehicle. Patricia Henderson had been following the tour at a distance, and now she spoke up. Your Honor, you can see how this equipment is completely out of character for a residential neighborhood. This looks like a construction site, not someone's home. Judge Mendoza turned to her. Miss Henderson, I have seen actual construction sites, and this is nothing like that. This is a well-maintained property with a single piece of equipment parked in the driveway. If I did not know there was an excavation in the backyard, I would have no idea anything unusual was happening here. Patricia's face reddened. But the covenant clearly states that large equipment cannot be stored in view of the street. The covenant is not my only consideration, Judge Mendoza said. I also have to consider Colorado law regarding mineral rights and reasonable use of property. Thank you all for your time. I will issue a written decision within 2 weeks. As everyone was leaving, Patricia made one more attempt to argue her case, but the judge politely cut her off and headed to her car. Marcus gave me a subtle thumbs up as he packed up his briefcase. That went well, he said quietly. She seemed genuinely impressed with your operation. 2 weeks later, the decision arrived. Judge Mendoza issued a preliminary injunction in my favor, stopping the HOA from imposing any further fines and requiring them to cease all enforcement actions related to my backhoe and mining activities while the case was pending. But more importantly, her written opinion included language that strongly suggested how she would rule on the merits. The opinion was 12 pages long and went through a detailed analysis of Colorado mineral rights law. Judge Mendoza cited multiple cases, including several Colorado Supreme Court decisions that protected mineral rights holders' reasonable use of surface property. She wrote that HOA covenants, while generally enforceable, could not be used to effectively nullify state-protected property rights. The key paragraph stated, "The defendant has presented clear evidence of valid mineral rights dating to 1873, well before the creation of the Ridgeview Estates subdivision, or its HOA. He has obtained all necessary permits from Boulder County and is conducting his mining operation in compliance with state and county regulations. The single backhoe at issue is necessary equipment for this legal operation. While HOA covenants serve important purposes in maintaining community standards, they cannot be enforced in a way that makes it impossible or impractical for a property owner to exercise fundamental property rights protected under state law. To hold otherwise would effectively void the defendant's mineral rights, which this court will not do." Marcus called me as soon as the decision was posted. "Brandon, this is huge. The judge basically told the HOA they are going to lose if this goes to trial. I expect they will want to settle now. He was right. 3 days later, the HOA's lawyer contacted Marcus to discuss a settlement. They wanted to avoid a full trial that would cost them tens of thousands in legal fees for a case they were likely to lose. The settlement negotiations took about 2 weeks. The HOA wanted me to agree to certain conditions like parking the backhoe behind a screening fence when not in use and limiting my excavation work to certain hours. I was willing to compromise on some points, but I was not going to accept anything that materially interfered with my mining rights. We finally reached an agreement. The HOA would drop all fines and violations against me, acknowledge my right to maintain the backhoe on my property, and agree not to interfere with my mining activities as long as I complied with all county and state regulations. In exchange, I agreed to park the backhoe in my backyard when I was not actively using it for more than 3 consecutive days, and to limit noisy excavation work to between 8 a.m. and 6 p.m. on weekdays. It was a reasonable compromise. The backhoe was usually in my backyard anyway, since that's where the excavation site was. I only parked it in the driveway when I needed to move it or perform maintenance, and I had no desire to run loud equipment early in the morning or late at night anyway. The settlement was formalized in a written agreement and filed with the court. Judge Mendoza approved it and dismissed the case. I had won, but Patricia Henderson was not done. About a month after the settlement, I was working in my backyard when Tom Bradshaw came over looking concerned. "Hey, Brandon, I just got a notice from the HOA about a special assessment," he said, holding up a letter. "Patricia is trying to charge everyone in the neighborhood an extra $500 for legal expenses incurred protecting property values. I think she is trying to make us all pay for her fight with you." I read the letter. It was carefully worded to avoid directly mentioning me, but the timing made it obvious. The special assessment was being justified as necessary to cover legal costs from the previous fiscal year. "Can she do that?" I asked. Tom shrugged. "I don't know, but a lot of people are angry about it. Nobody wants to pay $500 because Patricia decided to pick a fight she could not win." Over the next few days, I heard from several other neighbors who were upset about the special assessment. It turned out that Patricia had not consulted the full HOA board before filing the lawsuit against me. She had authorized the legal expenses on her own, using her authority as president. Now she was trying to spread the cost across all homeowners. A group of neighbors organized a special meeting to challenge the assessment. HOA bylaws required a vote of the membership for any special assessment over a certain amount, and Patricia had not called for such a vote. The meeting was heated, with Patricia trying to defend her actions and multiple homeowners calling for her resignation. I attended, but tried to stay in the background. This was not really my fight anymore. But when Patricia tried to justify the lawsuit by claiming I had been running an illegal mining operation that threatened everyone's property values, I could not stay quiet. "That's not true," I said, standing up. "I had all the proper permits and was in full compliance with county regulations." A judge reviewed everything and ruled in my favor. Patricia decided to file a lawsuit without board approval and without consulting a lawyer first about whether she could win. That's why we are all here paying for her mistake. Several people applauded. Patricia tried to regain control of the meeting, but it was too late. Someone made a motion to remove her as HOA president, and it passed with only 3 dissenting votes. The special assessment was canceled, and the board voted to cover the legal expenses from the HOA's reserve fund rather than charging homeowners. Patricia resigned from the board entirely a week later. I heard through the neighborhood grapevine that she and her husband were putting their house up for sale. She could not handle the embarrassment of being removed as president and losing the respect of the community. A new board was elected, and the first thing they did was update the HOA covenants to clarify that they did not apply to activities related to legitimate mineral rights or other state-protected property rights. It was a smart move that would prevent future conflicts like mine. As winter approached, I scaled back my mining operation. I had done enough exploratory work to confirm that the silver vein was real and potentially valuable, but I was not ready to commit to a full-scale mining operation. That would require more equipment, more permits, and honestly more time than I had while working my construction job, but I kept the backhoe. I had earned the right to park it on my property, and I was not giving that up. Some days, I would go out to my excavation site just to look at the progress I had made and think about the miners who had worked this same ground over 100 years ago. Tom Bradshaw stopped by one evening in early December while I was covering my excavation pit with tarps for the winter. "Hey, Brandon, I wanted to thank you," he said. "For what?" "For standing up to Patricia. That woman made this neighborhood miserable for years with her petty rules and power trips. You fighting back gave other people the courage to push back too. The new board is actually reasonable." "It is like living in a normal neighborhood now," I smiled. "I was just defending my property rights. I did not set out to start a revolution." "Maybe not, but you did. Dale would have been proud. He always said those mineral rights were valuable and not just for the silver. He meant they represented freedom, the ability to do what you want with your own land. You proved him right." We stood there for a while in the fading light, looking at the excavation site and the mountains beyond. Tom was right. This had become about more than just a backhoe or even mineral rights. It was about standing up to unreasonable authority and refusing to be bullied. The holidays came and went. I spent Christmas with my family in Denver and told them the whole story over dinner. My dad, who had never trusted HOAs, got a particular kick out of the part where the judge dismissed Patricia's arguments. "I always told you those mineral rights were gold," he said, then corrected himself with a laugh. "Well, silver in this case, but you know what I mean. Real property rights that nobody can take away." In January, I received an unexpected letter from a mining company based in Denver. They had somehow heard about my silver vein and wanted to know if I would be interested in leasing my mineral rights or selling them outright. The offer was surprisingly generous, enough that I could have paid off my mortgage with money left over. I called Marcus to review the offer. "It's legitimate," he said after examining the documents. "This is a reputable company. They must think your vein connects to a larger deposit they are interested in." "What do you think I should do?" Marcus paused. "That's your call, Brandon. The money is good. But if you lease or sell the rights, you lose control over what happens on your property. They would have the right to come in with their own equipment and do much more extensive mining. Is that what you want?" I thought about it for a few days. The money was tempting, but I had not gone through all this just to hand control over to someone else. The whole point was having the freedom to work my own land on my own terms. I declined the offer, but negotiated a consulting arrangement where I would provide the mining company with geological data from my excavation in exchange for a modest fee. It was a win-win. They got useful information, and I got paid without giving up my rights. Spring came, and I resumed my mining work. I had gotten better at the whole process, and I was now pulling out consistent amounts of silver ore. It was not enough to quit my day job, but it was a nice supplemental income and a fascinating hobby. The new HOA board left me alone completely. In fact, the new president, A reasonable guy named Jeff Martin, who worked as an accountant, stopped by one day to chat about my mining operation. He was genuinely interested in the history of the property and the mining techniques I was using. "You know, this is actually pretty cool," Jeff said, examining a piece of silver ore. "Patricia made it sound like you were destroying the neighborhood, but this is just interesting local history come to life." "That's how I see it," I said. "This land has a story and I am just the latest chapter." In May, the local newspaper ran a feature story about small-scale mining in Boulder County. They interviewed me and took pictures of my operation. The article was positive and focused on the historical aspect of mineral rights and how modern property owners were rediscovering old mining claims. Patricia Henderson's house sold in June. I never spoke to her again after the settlement, and I was fine with that. Some people just cannot handle being wrong, and she was one of them. Life settled into a comfortable routine. I worked my construction job during the week and spent weekends mining when the weather was good. I had become part of a small community of amateur miners and rock hounds in Colorado who shared information and techniques online. It turned out there were quite a few people like me who had discovered mineral rights on their properties and were exploring them as hobbies. My excavation site reached a point where I had extracted most of the easily accessible silver from the vein. To go deeper would require more sophisticated equipment and safety measures that I was not ready to invest in. I had pulled out about 200 pounds of ore over the course of a year, which yielded roughly 15 ounces of refined silver. Not a fortune, but enough to cover my equipment costs and leave me with a nice profit. I decided to take a break from active mining and focus on properly documenting everything I had found. I created detailed maps and geological surveys of my property, cataloging the vein structure and ore quality. This documentation would be valuable if I ever decided to resume mining or if my kids inherited the property and wanted to pursue it. One afternoon in late summer, I was in my garage organizing my mining samples when a car pulled up. A young couple got out and walked up my driveway. They looked like they were in their early 30s, casually dressed and friendly. "Hi, are you Brandon Crawford?" the man asked. "That's me. Can I help you?" "I am David Chen, and this is my wife Lisa. We just bought the Henderson house down the street. We heard about your mining operation and thought it was fascinating. We were wondering if you could tell us more about it." I ended up spending an hour talking with them, showing them my excavation site and explaining the mineral rights situation. They were great listeners and asked intelligent questions. It turned out David was a geologist by training, though he worked in environmental consulting now. "This is exactly the kind of thing that drew us to Colorado," Lisa said. "The history, the geology, the sense that you can still do something adventurous on your own land. Our old neighborhood in California had an HOA that would not even let us paint our front door without approval. Well, we had some HOA issues here too," I said, then told them the whole story. David laughed when I got to the part about the judge's site visit. "So the previous HOA president tried to seize your mining equipment and ended up getting removed from the board. That's poetic justice." "It worked out in the end," I said. "The new board is reasonable, and I think everyone learned that there is a difference between maintaining community standards and trying to control every aspect of people's lives." We became friends after that. David helped me analyze some of my geological data, and I helped him with a construction project on his house. It was nice having neighbors who understood what I had been trying to do. As fall approached again, marking 2 years since Patricia had first confronted me about the backhoe, I realized how much had changed. I had gone from being a regular homeowner minding my own business to someone who had fought a legal battle, 1. And helped reform an overbearing HOA in the process. I had also discovered a passion for mining and geology that I never knew I had. The backhoe sat in my driveway, no longer a source of conflict but a symbol of rights defended and freedom preserved. Sometimes I would catch myself looking at it and smiling, remembering Patricia's face when she marched across the street that first morning, so confident that she could make me comply with her demands. She had learned the hard way that some rights run deeper than HOA covenants, literally and figuratively. Mineral rights had been established in Colorado since the gold rush days, and they carried the weight of history and law behind them. An HOA covenant written in the 2000s could not override property rights established in the 1800s. I kept all the legal documents from the case in a fireproof safe in my house. The deeds, the surveys, the court filings, Judge Mendoza's opinion, everything. Not because I thought I would need them again, but because they told a story worth preserving. They were proof that standing up for your rights mattered, even when it was difficult and expensive and uncertain. Tom Bradshaw retired that year and decided to do some mining exploration on his own property. It turned out his lot was also part of the original mining claim area, and he likely had similar mineral rights. We worked together sometimes, sharing equipment and knowledge. It became a nice hobby for both of us, a way to connect with the land and its history. The following spring, I received another letter, this time from the Colorado Division of Reclamation, Mining and Safety. They were doing a review of small-scale mining operations in the county and wanted to feature my operation as an example of how to properly conduct exploratory mining on private property. A state inspector came out and reviewed everything. He was impressed with my safety measures, record keeping, and reclamation planning. I had always intended to properly fill in and restore my excavation site when I was done, and I had documented those plans with the county. This is exactly the kind of responsible mining we want to encourage, the inspector said. You have proven that property owners can exercise their mineral rights without creating hazards or environmental problems. I wish everyone was this thorough. The state ended up publishing a guide for small-scale miners that included photographs of my operation and citations to my permit applications as examples of how to do things correctly. It was a weird kind of fame, but I was proud of it. One day in June, I was having coffee on my front porch when a sheriff's deputy pulled up. My heart jumped for a moment, wondering if somehow the HOA had found a new angle to attack me. But the deputy was just there to serve as a process server for a completely unrelated matter involving a construction lawsuit from my day job. As he was leaving, he paused and looked at my backhoe. "Hey, are you the guy who fought the HOA over mining rights?" "Yeah, that was me." The deputy grinned. "I heard about that case. Everyone at the sheriff's office got a kick out of it. We deal with HOA complaints all the time, usually petty nonsense like trash cans being out too long or someone's lawn being half an inch too tall." It was nice to hear about someone pushing back and winning. After he left, I thought about how the case had rippled out beyond just my neighborhood. It had become a small but notable example in Colorado property law. Marcus told me that other lawyers were citing Judge Mendoza's opinion in their own cases involving conflicts between HOA covenants and state-protected rights. Summer passed peacefully. I did some maintenance on my excavation site, but no major digging. I was content with what I had accomplished and did not feel the need to push deeper into the vein. The silver I had extracted was enough to validate the whole project and then some. In August, the HOA held its annual meeting. I attended, something I had never bothered to do before my conflict with Patricia. The meeting was surprisingly pleasant and efficient. The new board presented a budget, discussed some minor maintenance issues, and took questions from homeowners. Nobody complained about my backhoe. At the end of the meeting, Jeff Martin made a point of thanking me publicly for my patience during the previous year's legal dispute and for working with the board to reach a reasonable settlement. Several people applauded. It was a small gesture, but it meant something. It showed that the community had moved past the conflict and recognized that I had been in the right. As I drove home that evening, I thought about calling Patricia to tell her about the meeting, to rub in how much better the HOA was without her. But I did not. There was no point. She had lost and left, and that was enough. Revenge was not why I had fought the battle in the first place. By the time October rolled around, marking 3 years since the whole conflict began, I had fully integrated my mining hobby into my life. I had a small shed dedicated to storing ore samples and equipment, a library of books on Colorado mining history and geology, and connections with other amateur miners throughout the state. The backhoe remained my primary piece of equipment, and it had more than paid for itself in extracted silver and saved labor. More importantly, it represented something bigger. It was a reminder that property rights matter, that individuals can stand up to organizations, and that sometimes the little guy wins. I never forgot what Tom Bradshaw had said about Dale Carson valuing the mineral rights as symbols of freedom. That had proven to be true in ways I never expected when I first bought the property. The freedom to use my own land, to pursue my interests, to defend my rights against unreasonable authority, all of that had come from those old deeds and the determination to fight for them. The story could have ended badly. I could have given in to Patricia's demands, moved the backhoe, and abandoned my mining project to avoid conflict. Many people would have. The legal fees alone were significant, and there had been no guarantee of victory. But I chose to fight, and Judge Mendoza had vindicated that choice. As winter approached again, I winterized my equipment and covered the excavation site. The mining season was over for the year, but there would be another spring, another summer of careful digging and discovery. The silver vein was still there, running through the bedrock beneath my property, waiting patiently like it had for millions of years. I sat in my living room on a cold December evening, looking at a small glass case on my bookshelf. Inside were several pieces of raw silver ore from my excavation, along with a copy of the original 1873 mineral rights deed and a printed copy of Judge Mendoza's opinion. It was my trophy case, proof of a battle fought and won. The whole experience had taught me valuable lessons about standing up for yourself, about understanding your rights, and about not backing down when you know you are in the right. It had also taught me about community, because while Patricia had tried to turn the neighborhood against me, ultimately the community had sided with reason over authoritarianism. I wondered sometimes what would have happened if I had just complied with Patricia's initial demand. I would have moved the backhoe, probably rented storage space somewhere, and maybe eventually given up on the mining project altogether. Patricia would have remained HOA president, continuing her petty tyranny over the neighborhood. The mineral rights would have remained dormant, unused and forgotten like they had been for decades. Instead, I had fought back. The backhoe stayed. The mining continued. Patricia lost her position and left the neighborhood. The HOA reformed itself into a more reasonable organization. And I discovered a passion that enriched my life in unexpected ways. Not bad for a guy who just wanted to dig some holes in his backyard. The backhoe sat in my driveway through that winter, covered with a tarp against the snow. It was not going anywhere. Neither was I. This was my property, my home, my mineral rights, and my freedom to exercise them. Judge Mendoza had laughed when she saw how thoroughly documented my rights were, and Patricia Henderson had learned the hard way that some battles are not worth fighting. I had won, and that victory tasted sweeter than any silver I pulled from the ground.